All right. Hello, everyone. Thank you so much for attending this webinar. My name is Chaitrali Karve. I work for LCR Capital. We have EB-5 projects for you to invest in. And I've been in the EB-5 industry for 10 years. And, one of the first words that are synonymous with EB-5 is source of funds, and a very important process for new investors. I wanted to provide some insight into what that means. And so we have Dennis Tristani here of Tristani Law Firm. And welcome, Dennis, and thank you so much for giving us this hour of your time. I know how slammed and busy you are. I'm going to let Dennis introduce himself, talk a little bit about his EB-5 journey, and then we'll get started on source of funds. Dennis?
Yes. Well, thank you, Chad. Thank you to the entire LCR team for having me here. I know we're all busy, but it's a pleasure to be with everyone. My name's Dennis Tristani. I am the founder and managing attorney of Tristani Law. We are based just outside Washington, D.C. in Rockville, Maryland. I've been in the EB-5 space since 2013, having traveled extensively throughout India, China, and other parts of the world on my EB-5 journey, doing seminars and conferences and the like for the better half of the last decade. We opened our law firm in 2021, and we focus our practice not only on EB-5, both direct and regional center based, but we are a full service business immigration law firm. But again, it's wonderful to be here. I think this will be hopefully super helpful, and obviously, we can use the entire hour to not only discuss, varying source of fund strategies and things to look for, pitfalls to avoid, what USCIS is currently looking for in terms of their own adjudication standards, but we can obviously open this up for question and answers, I'm assuming. So happy to help.
All right, everyone, we will have time for question and answers. So let's dive in, right? I really wanted to start, Dennis, with this whole starting with you explaining why the source of funds exists, right? What is USCIS looking for? Why was it incorporated into this process? If you can give us your
Mm-hmm. Yeah, no, it's a good question. Generally speaking, USCIS and really the US government when EB-5 was made into law, uh, the process is meant to spur economic activity, spur job creation through foreign direct investment. Source of funds requirements exist to essentially to simply vet the funds that are being invested into the US. So long story short, there's other visa programs that also have source of funds requirements, such as the E2 visa, for example, and all source of funds requirements for any U.S. visa-based program are meant to confirm that there's a lawful source of the funds that are being invested and a clear path, right? So a clear path from origination, from where the funds are being earned, to eventual investment with regional center, for example, or your own direct investment project. So the law is in place to essentially ensure that funds that were unlawfully earned are not being invested in the U.S.
I used to always say in my time that if you're not a drug lord or it's not terrorist money, you should be.
Right, right. Yeah, it's they're not out to get you, right? They're not assuming there's not an assumption that funds are illicit. You just there's an objective documentation requirement to sort of get you over the evidentiary hump in terms of just proving where funds come from. So and again, yeah, they're obviously looking to stop people that launder funds or earn money illicitly. Those are the individuals they don't want immigrating to the U.S. for obvious reasons.
So when you say source of funds, are we looking at their entire, we've had investors, are we looking at their entire net worth, or are we just looking to source a certain amount? What's your perspective on that?
Yeah, and it's a good question, and it's frequently asked. There's other visa programs around the world. Notably, Canada used to have an investment program that had a net worth test, and actually required documentation to prove your net worth or a certain net worth. USCIS and the way the laws were drafted and the way the policy is being implemented is you need to prove the 800 that you're investing, right? And there's been recent court activity and litigation that's actually further sort of honed that down into essentially you need to confirm the path and source of the immediate 800 that you're investing and any admin fee that you're paying to the regional center. So because those funds are typically transferred together or out of the same bank account, you do want to source and have a clear path for both. But we're not, if you earned income abroad, if you have other earned income that's not related to the funds you're investing, we don't have to disclose that. We don't have to provide documentation to confirm where that come from because it's not relevant. That's a good question though.
Yeah, yeah, that's really good to know because sometimes, especially high net worth individuals originating in India, have always had that question for us, for us the providers. So when an investor first engages you, um, what does that process look like? How do you kickstart that process on your part? Or we can divide this. I want to divide this question into two, where we will get down to the specifics of documents or your tips to it. But what is generally after, we've always encouraged our investors to have a quick call with you, and then they go ahead and engage you. And then how does that process look like from your end?
Yeah, that's it. Good question. So, I think, any attorney would probably tell you the same thing. You have to have an initial call with your prospective client. I think typically, if you're looking to begin the process and looking to file sooner than later, for a variety of reasons, then, discussing source of funds with your potential and, the immigration firm you're looking to work with is helpful because most firms will provide, the investor with a document checklist, right? So the way we, begin any engagement after we've, formalized the relationship is by tailoring a document checklist, not only for biographic documents, but for source of funds documents based on our initial conversation. Given the advent of partial filings and the ability to get the immigration paperwork started with a partial filing, a lot of time we'll focus our documentation collection and review efforts initially on the documents that even prove where that first installment's coming from an efficiency standpoint. But, at the end of the day, it's, an initial call with, law firm, sort of discussing the strategy, timing, where funds are going to be coming from. If there's other potential sources, we can evaluate those, on the initial call. And then eventually there's a tailored document checklist based on, historically what USCIS wants and what we know they're looking for currently in terms of, recent adjudication trends. And then, we start collecting documents and putting the package together.
Okay. So do they like simply logistics, right? Like I'm just curious, and you would think with 10 years in EB-5 I would know, but like do they upload it to a Google Drive, or what are some of the safe mechanisms that are in place, right? Like technically.
Yeah. I mean, whether it's Dropbox or Google Drive or a secured Dropbox that's part of a law firm domain. Every firm's going to be a little different in terms of the way they operate. But we prefer a secure cloud through Dropbox, or sometimes our clients will have a secure drive they prefer using, whether it's Google Drive or the like. I think that's the easiest way. I don't like, lots of documents being sent through email. I think it's just a recipe for documents being lost. We like Dropbox or any other type of, secure cloud because we can create folders, we can label them. All our, we do that for our clients in the sense that we'll create a Dropbox for you if you'd like, and we'll have folders that correspond to the sections in the checklist. So we're not asking you to upload, 50 PDFs to one folder. We'll have specific folders that correspond to the different sections in a checklist so we can keep things organized. And obviously that, expedites our review of your documentation, and sort of organizing the case. But yeah, something secure and cloud-based is typically preferable.
So typically a folder would, so if it was my folder, it would look like maybe tax, like a subfolder for tax returns, W-2s, bank statements, the,
Yeah,
the graphic, like pretty much organized in
ex-
that.
exactly. So you could have earned income, and then that gets broken into W-2s, tax documents, bank statements, pay slips. You could have a property folder for a HELOC, so we'll have initial purchase documentation, HELOC loan documentation, and eventually you can have a lot of subfolders. The more you divide, we don't need a million of them, but I do think it's helpful. Although we always ask that you try to label PDFs if possible, so we sort of know, where to pick and choose, know to, what we're looking for, especially if we have follow-up calls with clients. It's helpful to be able to know where documents are and to all be able to be on the same page. But that's typically how the sort of organizational process would work.
Okay. All right. So I want to take a little break and share a fun fact that in 2019, when the amounts changed from 500, remember what a crazy time it was? And
I
in those
do.
days, we were sending all the documents manually. I have a picture of a FedEx truck on the last few days that was full of these boxes that were petitions. So are you guys able to submit them electronically now, or are they still paper documents?
Oh, we can. USCIS has a way to do it. I don't, just because I don't particularly like the system. I don't, not that I don't trust it, but because I use it for other cases. I use it for simple family cases, whether it's I-130s or N-400s. Online filing can help, in terms of simpler cases. Uh, I don't, I routinely speak to, many attorneys in the industry who I'm colleagues with, and I don't know one that really uses the online system, simply because it's not tested. We know that FedExing things overnight to the investor program office will get the documents there. If you filed hundreds or thousands of these, that's the way to to file the case. You can upload additional documents online. I assume the portal works. If you're supplementing a case, but I still do my supplements through FedEx, and then I write to the IPO to let them know that I've interfiled, I've submitted supplemental filing for a particular case, and that's worked. I maybe a little old school, but especially with the government and their online system having lots of technical issues, over the years, I prefer to file through FedEx, and it's just sort of the old way.
It's pretty amazing that USCIS still uses the mail system and keeping FedEx in business big time, right?
They keep the postal service in business as well. That's when they send out correspondence to the postal service. So that's, yeah, they're stuck behind a little bit, that's for sure. They still review, they still look at cases, paper and pencil on their desk. They scan everything in electronically, but the reviewer may very well have piles of paper on their desk, and that's still the case today.
I do want to address one point really quickly is we're not sending project documents anymore, right? The F approval has now accomplished that, so we're not attaching the whole project documents anymore, or are we actually attaching that to the petitions?
You don't need to. Every regional center is a little different in terms of what updates they may have. Um, some may prefer to include parts of the filing they believe are more important. I think, for the most part, no, right? As long as there's an F receipt, or as long as the case was delivered, we don't have to, and it's great. It saves paper, it saves costs, it saves time. That's one of the best things they've done is sort of, you have one project filing and that's it. Obviously, if there's updates to the project, if there was an amendment, if there's a new receipt notice, the smaller project filing packet that would typically include your offer, your signed offering documents and the like may change over time depending if there's any updates to the project. But yeah, we're not printing out the thousands of pages that we used to, fortunately, which is a good thing.
Just, I do want to enhance this point. In old days, every petition, um, we attached all the project information. So that's what we were talking about. So we've talked about what goes from Dennis's office. So Dennis, give us a picture of what happens at USCIS when that petition is received.
Oh
What
gosh.
on?
Yeah, so it's a good question. So I frequently get the question, where are we filing? Can we file to a specific service center because we've heard that processing is quicker at a specific service center? And for I-526 filings, there's only one place we can file both a standalone I-526 or regional center-based I-526 alone, or even with adjustment of status documents and the ancillary 765 and 131. There's a lockbox in Texas. That's where we file, and it's been the case forever. The case gets taken into a big room, yeah, the mail room, and then the cases are split up. The I-526 goes back to the IPO in Washington, D.C., where it's adjudicated. So I live and work just outside of the city. So I send things to Texas and it goes right back to D.C. The IPO, the Investor Program Office that adjudicates everything related to EB-5, 526s, 956s, 829s, that's in Washington, D.C. The adjustment of status, the work permit and travel permit are then routed to a different service center, whether it's California, whether it's Nebraska, whether it's the National Benefits Center, whether it's Texas. And that service center will issue the receipt notices. So when you get an I-797 receipt notice, whether it's for really any form that you filed, you'll have the service center at the bottom. That's the service center that's adjudicating your case. They may transfer it. It's very, very common for cases to be transferred for, efficiency purposes, whatever that means. But it's very frequent for 485s, the work permit and travel, advance parole to be moved around. You'll get a transfer notice whenever that happens. It's not a bad thing. It's not a good thing. It should be a good thing if it's for efficiency purposes, but it typically means they've just shuffled your case off for processing purposes.
So it really not, has nothing to do with the residence state of residency or anything, right? Like
No, I mean, it
resident.
could, it could in terms of how USCIS, formally adjudicates things at the end. To be very honest, I haven't seen any correlation between where my clients live and the service center that a lot of clients live in Texas. They're being processed in Nebraska and in California and not at the Texas service center. It's because certain service centers just have, every service center has certain capabilities and certain, goals, right? They have certain cases they're processing. Now, other forms you may have filed in the past, whether it's an I-140 or an I-130 or an I-129, those will have more specific instructions on where to file based on where you live or based on where the business is located. But in the I-526 context, it's pretty straightforward. You have to file in Texas, and then things will get shipped off to their final sort of resting place in terms of final adjudication, and that service center will send you the receipt notices.
I have a retirement plan for you and me. We will turn into two little flies and we will be in the office in Washington, D.C. and find out all the information that goes on and then
Right.
retire, right? I always wanted to be that fly on the wall to see how these workings occur. So
Yeah, yeah, yeah. Me too.
I bet, right? That would be proprietary information we can use. But
Yeah, exactly.
moving on. So there are two types of receipts, right? When the petition is received, can you walk us through that?
Right. So in terms of actual receipt notices that
Yeah,
clients will get after we
what's
file?
the difference between the lockbox receipt and the 797 receipt?
Oh, sure. Yeah, it's another interesting point. So for the last couple of years, really since the RA passed, USCIS was issuing a lockbox receipt without a receipt number. So it had your name, the type of petition you filed, either standalone or regional center based, and it had whether it was located in a rural area or targeted, TEA or non-TEA. It's interesting. I'm not seeing them issued all the time now. I'm seeing a lot of my clients are just getting the formal notice and they're getting it very quickly. So I have some clients that are getting a formal I-526E with their receipt number in a matter of weeks. I have some clients that's still taking 4 weeks, sometimes 5 weeks. It's very sort of all over the place. It's interesting. I'm only, I would say for at least the last 3 or 4 months, and it's very possible other attorneys are having different experiences, but I'm only getting that initial lockbox receipt for direct cases. I do a fair amount of direct work, and so I'm still seeing that initial lockbox receipt for direct cases, but not for I-526Es, which is fine with me as long as we're getting a receipt notice timely. It used to be that we were getting this initial receipt notice with just the investor's name in like a week, sometimes 3 or 4 days. And
Right.
the check would get cashed like that, but then it would take 2 months, 3 months sometimes to get a formal receipt notice. So and interestingly, that initial receipt notice you're talking about, that lockbox, that was issued in Texas at intake. And then the formal receipt notice is issued at the IPO in DC. So I'm, I'm hopeful now that, I guess the IPO is, things are sort of lined up in a way now where we're just getting a formal receipt notice. It's less paper, less confusion really. Clients will get this initial notice and say, where's my receipt number? How do I track anything? And it's like you can't. It just says that they've received something. So that's what I'm seeing as of this calendar year.
Okay. And just from our side, we do need that receipt notice in order to release the funds from the escrow, right?
Right.
That that's our fund administration process that mandates that. So that's I'm really glad we address that, because sometimes I think all of our prospective investors and investors spend so much time worrying about their source of funds, and then they're always worried about when is my capital going to be released, and it gets released on the receipt of that notice, so I'm
Hmm.
glad they're sending them to us quicker and
They
faster.
are. Yeah. It's yeah, it's if whenever USCIS does anything more quickly, it's a win.
Absolutely. So for investors today that are planning to go through this process without any, everybody's always worried about the categories being current, right? For
Mhm.
India born, China born, that's a big worry. But if that didn't exist, what would be your ideal time frame? Like if you were to um, tell an investor how much time it takes for you to finish the source of funds and file a petition, what is your ideal time frame? Is it 4 weeks, 2 weeks, 6 weeks?
No, I mean,
What your
look at,
dream one? Yeah.
yeah, well, I mean, I don't like having work just hanging around, right? We run a lot of great attorneys in this industry. I know run really tight ships. They have great processes, and I believe that's what we do as well. It does take time, though. I have clients that want to file in a week, 2 weeks, and if your documentation is incredibly straightforward, if the funds are ready, if you've already started the subscription process, then yeah, you could file really quickly. Um, that being said, I'd say a vast majority of my clients, 4 to 6 weeks, sometimes 8 weeks. I think it really depends, and it depends on a whole host of things. Source of funds documentation can be very straightforward. If you're selling RSUs, and and that's the entire, source of funds you use, and that's very straightforward. If you're selling 3 or 4 properties, if you have gifts or loans from family members, the documentation is going to be, more complex. And again, I especially nowadays where, we're going month to month with the visa bulletin in terms of being current and in terms of getting adjustment of status. And again, as I mentioned, we can partially, you can always file the immigration paperwork if you're in the process of investing. So what I tell clients is, if you're going to do a partial, we want to generally know where all your money is going to come from. Anyways, the regional center is going to know that. We want to make sure we can document it properly. But in terms of initial documents to upload and vet, we do want to focus on the documents that prove where the partial funding is coming from first, just so we can speed up our preparation process and review the other documents, once we've vetted the first set, if that makes sense. So, you know, uh, I'd say 4 to 6 weeks is pretty common. Sometimes 3, sometimes 5. Again, and project selection is incredibly important. It's a huge amount of money. I never want to rush my clients. We're happy to work as quickly or as not quickly as you'd like, so to speak. But I think that it's good to be efficient, but it's, and quick, but it's really important to be accurate. You really get one shot at doing this right. Obviously, working with, a good law firm or attorneys is obviously incredibly helpful, and working with good partners because it's a long relationship. But you really want to make sure the documentation you're providing is accurate. That's what we're good at doing. But any attorney will tell you that they know what USCIS wants to see. And if they don't see certain documents, they're going to issue an RFE. And so I'd much rather make sure we have the documents I know we'll need, than rush a case.
I do. I have to say that really the idea to do this webinar came out of just what you explained, is that as I talk to prospects day in and out, I'm noticing that a lot of them are doing their due diligence first, kind of narrowing down on 1 or 2 projects, and then they are engaging attorneys, and having done this for 10 years, I have to admit that I was surprised, because in good old days, people always said, "Okay, we're going to do EB-5." They engaged an attorney, did their source of funds, and then they were picking up the projects, and as the
Hmm.
was going on, and
Yeah.
especially India-based investors, where 5 days of the week are really 2 days, right? So 4 to 6 weeks would go by very quickly, So,
Yes.
and then
Yes.
every investor I speak to, they're like, "Oh, our source of funds is very clear, and we can file in no time." And I always want to say that even no time in this world does mean 3 to 4 weeks. Anything sooner is just not possible, between going back and forth with the documents and
Right. Yeah, no, you're 100% correct. And most firms have more than one case on their docket. Most firms have good staff that can, help process things efficiently. But, again, there's always an understanding that, we can't start reviewing, we can't start putting the case together until we've had an initial conversation and you've moved forward with the engagement, right? And so obviously with any engagement, services engagement in life, that means, paying a deposit so the service provider can begin work. So I think that's, probably part of the hesitancy in terms of moving forward with a service provider, is you want to make sure you're actually going to invest, right? You want to make sure you're going to move forward with this process, and there's a project you like. You don't want to spend money out of pocket. I totally get it before you actually know you're going to do something.
yeah. And I really do like the process, right? Because it allows them to evaluate the whole decision to even invest the 800,000, So, and I think that as they talk with many of us, it's an education process, because really understanding EB-5 just from USCIS's website or several guides that float around can be pretty difficult, right? It's only even learning about EB-5 has a learning curve of 4 to 6 weeks before you know what's going on. This, what is this?
Yeah.
What is an RC?
No.
Like the most favorite word, RC. What does it really mean? For sure.
Hmm.
Um,
Hmm.
I know we may have a lot of questions, so I wanted to now just drill down into uh, a couple of specifics, right? And maybe just maybe one of the topics that I wanted to discuss was uh, let's talk about alternative sources of funding, right? Like besides RSUs or savings. And so I want to start with self-directed IRAs. If you could provide a few guidelines on how they can be used, and um, can a couple have both of theirs, or does it have to be primary investor? Just start.
Yeah. Yeah. No, it's a good question. It's a novel strategy, I would say. Fortunately, these cases are getting approved now, which is great. And there's been tremendous work done in this industry. I would say over the last year from different law firms and regional centers that have sort of spearheaded and used this type of strategy within the law because it makes a ton of sense. Generally speaking, it's a self-directed IRA, is a vehicle where you can use old retirement funds. So say, for example, from an old 401k from an old employer, not your current employer, but an old employer, and you can transfer those to a custodian that essentially manages the SDRA on your behalf, akin to a trust. And you invest those funds into an investment of your choice. In this case, it's, to the NCE, right? You're investing in essentially what's akin to a private security when you're making an EB-5 investment through a private placement memorandum, but you're using your old retirement funds and investing directly to the NCE through the SDIRA. So at the project level, at the subscription document level, there are some amendments that the subscription documents have to be drafted in a way to allow that. Okay. Again, nowadays in today's market, LCR and there's other regional centers that are working with certain custodians to facilitate the SDIRA process for prospective investors. Um, it's a nice way to use old 401k funds, for example, without withdrawing, without incurring, a tax hit. And so I have a lot of clients that are looking at this if they have an old 401k fund from a previous employer. To answer your question, you can't. So it's one where it's primary investor, right? You can't combine two 401ks in different people's name into one STIRA. That won't work. So typically, what you'll see is, the primary investor, perhaps, say one of the spouses has a larger retirement fund. They'll use an SDRA with that larger fund, and then the other spouse's income can obviously be pooled with the primary investor's income. That's never an issue. But it's a novel technique. I think I've always thought that it would work. I think at the onset, many attorneys were not necessarily skeptical, but you never know how USCIS is going to react to a new strategy, especially something they may not have seen before. But that's generally how that works. In sort of a quick summary.
Approval that sets a precedence, right? So we can use that. I think we were all very innovative a year and a half ago, and but skeptical, and that now that we have several approvals, it's really starting to be a standard, especially in the
Hmm.
US market for sure, right? Yeah,
Yeah.
it's really I have personally, I mean, seen them used to purchase real estate and things like that, a
Yeah.
lot in good old days,
Yeah, it's always been a good way to invest in something else, right? You don't want to just invest in your typical market funds or ETFs. You have you have a private investment you want to pursue. A lot of time it's in real estate. But you know,
And
the
to protect the tax implication of having it
yeah,
outside
yeah,
401.
exactly. I mean, breaking, withdrawing early is, you're going to get hit. And so it's just, it makes a lot of sense now. And again, I really, it has been 18 months, really. I would say it's probably been a year and a half since this idea was really floated around. And there are a few firms that were doing it early on. And here we are.
That's what makes EB-5 so amazing, you know. I we have about 20-25 minutes left. Let's touch up on a couple of topics really quick, and then we can open the floor for questions. One of the questions or one thing that I wanted to take a few minutes to talk about on behalf of us issuers is for the investors to know that once they make a decision, the document execution process um, does take 3 to 5 days. And a very important part of that is the investor eligibility verification, right? So could you explain that a little bit to our investors in layman terms?
Yes, with the caveat that I'm not a securities
Yeah,
attorney.
ab- absolutely.
But there regional centers, any issuer, generally speaking, of privately not registered with the SEC securities. And there's a whole lot of nuance I won't get into, but generally speaking, most regional centers nowadays will want the investor to be accredited, right? So there's securities regulations that essentially, in layman's terms, say that if you have a net worth of more than $1 million, not including your principal residence, or if you and your spouse, if you make more than 200 over the last 2 years, or you and your spouse make over 300 over the last 2 years, you're accredited, right? And so the reason these laws exist are to protect investors, right, from investing in securities that aren't registered with the SEC. So the issuer, right, the regional center, as part of their onboarding process, will, if you're located in the US, not if you're located abroad, but if you're located in the US, are you an accredited investor? Okay, and so the determination of whether someone is accredited can be done by a number of licensed professionals, including attorneys, or other financial professionals. And in order for you to actually move forward with the process, they're going to require you to have this verified, right? And so again, that process involves either your immigration attorney or other financial professional or CPA reviewing documentation you provide them, and or having communications, oral or written communications that confirm, generally speaking, how much you earn, how much your spouse earns, or how much your net worth is in terms of assets. And again, that's not an immigration, it's not a specific immigration requirement. That's a requirement the SEC mandates on any issuer of a private security, including a regional center.
Oh, thank you very much. That was a great question. I wanted you to just do a 5 minute explanation on why we use a fund administrator and how the funds flow and how they're really important for the 829 stage, right? Which is really the bigger immigration risk to the investors related to a project than is just the 526E filing.
Right. So, generally speaking, and it probably makes sense to just, what's required at the 829 stage. And a lot of my, clients will ask me that because it obviously is a very important petition. If you're investing through a regional center, right, if you're not doing this on your own, there's not a whole lot you, the actual investor, will do at the 829 stage, right? Because you provided your source of funds documents, they've been vetted, they've been approved. The 829 stage requires a few things. It requires that there be evidence that the investor has invested and sustained their investment at risk for a a certain number of years that is obviously currently subject to interpretation and still sort of up in the air. Right, so your money has to move not from your account, but to the NCE, and then it has to move down to the project. Okay, and so fund administrators help provide verification and help essentially provide evidence that that's occurred from an objective third party. Okay, and you want that because at the 829 stage, many years have passed, hopefully not too many, but many years have passed since you filed. Your immigration attorney is going to write to the regional center and say, hi, my client needs to file their 829 in the next 4 to 5 months. What documentation do you have? Where's the project template that we need to file, right? And some of those documents are going to be evidence of the precise path of your funds from receipt down to the project, okay, to prove that your money went into the project and stayed there, okay, for a certain period of time. Okay, there's other tax documents, K1s and such that we'd also need. But again, that's one of the reasons fund administrators are used, is to sort of have this clear and concrete set of documents that meet that, that essentially prove the legal requirement of sustainment at the 829 stage. Okay, and obviously job creation is another requirement that's met through an economic study. But that's sort of the long and short of it in terms of why they're used.
Yep. And then we obviously provide the K1s that show that and they get attached to the 829 petition also, right? For sure. All right. We're almost at 45 minutes. This
45.
I do have a lot of questions, Dennis, and everybody, please type your questions in the question and answer box, and we'll try to get to it. So our first question is, crypto brought, crypto as I guess source of funds. If the crypto was bought a long time ago, would that be a authentic source of funds?
Potentially. I have a lot of clients that have used, um, digital assets as part of their, not to invest digital assets directly, but the sale of digital assets and investing the proceeds. I mean, the way to look at crypto generally, it's like any other asset, right? Whenever you sell an asset and use the proceeds of the sale to invest, the government will generally want to know how you purchased the asset in the first place. So, again, RSUs and employer issued stock, very simple, right? They're issued to you through your employer, they vest, you sell them, and you receive the proceeds. A brokerage history that includes, a Coinbase or a Kraken or any type of digital asset brokerage that goes back many years, it may be a bit more difficult to confirm how you originally invested, especially if you invest over time. So there's ways to document that if you routinely invest. Obviously, if you invested $100,000 10 years ago, there's a transaction that occurred. So we sort of start from there and work backwards, right? Where did the funds come from that you initially invested that have now appreciated over time through the market, right? That's the answer to the question, right? It's looking at the origination point in terms of how you purchase the asset that you're now selling. And there's a ton of nuance depending on when you purchased, how, and if you did so over time. But so the answer is yes, it could potentially work. I just need a little bit more information to sort of flesh that out.
Okay. All right. Our next question is, what are typical RFEs you've seen for the source of funds, especially for those living in the US and providing their funds that are US based?
Um, it's a good question. We don't, if the funds are US based and earned relatively recently, again, RFEs are generally issued when there's either documents that aren't clear or there are sort of, holes in the path, right? So again, the way I look at source of funds generally is we work backwards, right? That's what the government does is they look at you, they look at your bank statements and you've wired $800,000 to the regional center. What made up the bucket of funds immediately before you sent that money out? Typically, my clients will pool funds. Maybe they have funds coming in from a HELOC and they have accumulated savings and they sold funds on Robinhood and brought them over. So we're very detailed with those final transactions. If you have large deposits or any deposits that are coming in to your bank account and that are mixing with all those funds that are being used and aren't disclosed, the government could ask about them. Okay. There are even nuances to that particular situation if you had more than enough money there anyway. But that being said, typically, if you have USCIS mandates 7 years of tax returns now, regardless of if you had 7 years of income you used, even if you just used income from the last year, they want 7 years. So if you're missing a tax return and tax transcript, they may flag it. Identity documents. So again, if anyone's loaning you or gifting you money, they need a copy. They want a copy of the passport. They want to identify that person. So that typically, because that's something you just may not think to include. And again, it's we don't receive a lot of RFEs, which is a good thing. Granted, you see them much more frequently with funds that come from overseas that may have documentary issues or may have, again, transferring funds from overseas can be a little trickier depending what country you're located in. I tend to think from the U.S. standpoint, it's you want to work backwards. So if someone's gifting you funds, or can gift you funds, you want to be candid with the person, whether it's family or friend, and say, hey, the government's going to want to see your W-2s and tax returns and bank statements and pay slips if the money's from your earned income. There's just no way around that. Some people may not want to provide that documentation, but it's just if certain documents aren't included, you'll very likely get an RFE unless the officer just happens to to miss it, but that's relatively infrequent. So that's again, it's a good question, sort of a broad question, but you as long as you have all your ducks in a row in the documentation, you have a clear path and it's very, it's clear where the funds are coming from, you're going to be fine. It's when other funds come into the mix that are used that aren't really identified in the narrative that you can get questions.
Dennis, I have a question of my own. I've always been curious. Like, do they, before their final approval of 5 to 6E, is there like a security check that's run on the primary applicants, like an FBI sort of a check to see if they have criminal history or not?
I mean, generally speaking, yes. So, I mean, USCIS can, they can reach out and they do use other security-based, I should say security agencies, whether it's, within DSS or the FBI. Yeah, so 100%. Especially if you're adjusting status, USCIS works with the Department of State to get, records from overseas. You have to disclose any criminal history with any adjustment of status application. If you don't, that's a huge problem, especially if you knowingly not disclose something. But they do. In today's world, if your funds are in certain countries or if you're from a specific country, in our current state of political theater nowadays, your application could receive more scrutiny than others. There's also USCIS is very comfortable with documentation from India, China, Vietnam, Brazil, South. These are countries that use the program. Sometimes if you're from a country that doesn't use the program and they're not as familiar with the documentation, that may, it may cause them to slow down a little bit. And so there's a lot that goes into these adjudications, but USCIS 100% speaks to other agencies. They can pull data from, there used to be there used to be a huge trend, and it's something to still look out for. If you filed any visa application, a DS-160, for your H-1B stamping abroad, the answers you provide to the Department of State are part of public record in terms of internally, right? So USCIS can cross-check information you provided there with information you provided on your I-526 form. We used to get requests for evidence all the time for people that said they worked for company A and company B on their DS-160, And then their resume that we included or their work history on the I-526 was different. And even if it's not relevant to the source of funds, the government, is flagging, potential tie-ups and saying, explain. And so it's important to know that they 100% talk to each other. All these agencies do. And if USCIS needs assistance, whether it be a background check, or any of the like, they will do so.
So driving tickets are not criminal offense, right?
No, no, no. Gosh, I mean, we could have a whole webinar on the intersections of immigration law and criminal law. But yeah, if the fine's not over $500, you don't even have to include documentation. You can say, yeah, I had that's two speeding tickets, $100 each. That's fine. If it's like a bigger moving violation, you have to include a copy of the citation. But it's generally not going to be an issue as long as you didn't hit anyone or you weren't, it wasn't really, really serious.
Okay, that's good to know. I might have reported otherwise, but
Yeah, no.
on to our other next question. So this question is, it's good to hear about SDRI. What other sources of funds are a yellow flag for USCIS? Like, is it stock secured by line of credit, HELOC? Um,
I mean, no source of funds are necessarily a red or yellow flag as long as there's good documentation to support them. With any loan agreement, right? Whether you're an unsecured loan or you're borrowing money against your house, your car, any type of secured loan, the loan agreement has to confirm that you can use the funds for either whatever you want or that there's no restrictions on how you use the funds. So it would generally be pretty rare for a personal loan or a HELOC, for example, to say you can't use your money for an investment, but you need to check that language because if there's general restrictions against using the money for an investment, they could say, well, you just invested your funds for EB-5. And so we always look at the loan documents, but I tend to find the easiest thing to do is, before you even, you know, go into the underwriting program, say, hey, I want to make sure, are there any restrictions on the loan I'm taking out? So that's something to look at for sure. But HELOCs are very straightforward and perfectly fine. Lines of credit against your stock, margin loans are again, the underlying asset is what USCIS cares about for any secured loan. So in a weird way, unsecured loans that are straightforward and have no restrictions, if they're issued by a bank or a large institution, that's going to be really easy. That's just the document. That's just a loan agreement. A HELOC, we have to confirm how you purchased the home that's securing the loan. Okay, so that's going to involve it's going to involve house documentation, closing documentation, and financial documentation from, potentially some time ago. Okay.
That you kind of partially answered our next question, which was about unsecured loans. And you did say that in some ways, if they're from a big financial institution, they're easy to explain. But this particular question is about if the underwriting asks for a reason for this personal loan, is there a specific wording you would like these investors to use?
Yeah, I mean, I should be as straightforward as possible. Yeah, you're using it for a private security investment for an EB-5 green card petition, right? Because if you say to remodel your home and USCIS says, well, that's not what you're using the funds for. Prove to us that you didn't lie to the bank to get this loan. Do they have any restrictions on using the funds for an investment? Again, I'm being a little dramatic, but US, you could see an RFE that says you didn't tell the bank, you weren't truthful to the bank. So don't say, I always say don't say you're going to use it for something if you're not going to use it for that process. Again, most banks credit they want to loan you money, right? They want the interest. They don't care if you burn the money, generally speaking. There's some, depending on the state you're in, there may be local restrictions on sometimes for using funds for higher education and the like, but just be honest, it's a private investment for immigration purposes.
Okay. That's a very helpful tip. Thank you very much for that. Uh, I think every time we should always have fun opening the Pandora's box, right?
Right.
one being the retrogression. So,
Oh gosh, yeah, okay.
what do you think? Do you predict retrogression? And I mean, obviously, China, India would be the big countries.
Yeah, I mean, there's a lot of great stuff written out there. I have wonderful attorney colleagues who they do webinars every month on retrogression. I recommend signing up for them. They're great. Joey and Charlie do one every month. Just you can't get you can't get much better than someone that used to work for the State Department talking to you about the visa bulletin every month. But all that aside, I tend to agree with with what a lot of my colleagues would say is that it's coming, right? And the reason we don't have a wait list in rural or high unemployment for the reserve categories yet is because we have insufficient adjudications by USCIS and or consular officers abroad that are sort of requiring actual visa numbers to be used in the fiscal year, right? So there's pent up future demand in both categories, especially for China and India, meaning there's a lot of pending I-526s, but that's not what the Department of State looks at when they're actually issuing a final action date, right? When they're actually doing a cutoff date, they're seeing how many I-526s have been approved by USCIS, how many DS-260s have been adjudicated and consular interviews finalized abroad, and that's when they make future predictions in terms of issuing a cutoff date for the final, for Chart A. Okay. Um, we don't have one in April. Typically in prior iterations of the visa bulletin in the past, where we've seen, the a warning from the Department of State saying there may be a need for a final action date and a set of categories is it's taken anywhere from 3 to 6 months for a final action date to appear. So in prior iterations, it's been June, July. Okay. Um, Typically, you could have a situation where maybe the May visa bulletin says, okay, now something's really coming in the next few months, right? So, the hope is you'd have that. You wouldn't just have the next bulletin have cutoff dates, which would make a lot of people want to file for adjustment of status very, very quickly. Um, Whether or not it happens in May, June, July, it really depends on whether USCIS can continue to adjudicate I-526s at a decent pace. We're seeing some approvals come through for cases filed a year ago, year and a half ago, even sooner than that, but it's not at a blistering pace. And I think, I think a lot of attorneys would say the same. You're not seeing dozens upon dozens of approvals each week. And so when you don't have those approvals, you don't have visas actually being pulled. Um, at the end of the day, the visa bulletin was released. April's current, which is great. Means you can file your adjustment of status, your EAD, your advanced parole. The visa bulletin for May should be released at the beginning, first 10 days of April, and um, we'll have to see what that says. But for investors, looking to file soon, it's great news, especially if you have kids that are getting older, and you want to, ensure that, their petitions are part of they're part of the process. Um, so that was a long-winded answer, but hopefully that
Um,
that cleared things up. Yeah.
Very important question. Here's a USCIS one, so why did USCIS retrogress unreserved category when they know there are no new applications left to adjudicate? Um, I guess,
Right. Go ahead.
yeah, the pre-RIA petitions would fall in that category.
Yeah, so it's the visa bulletin is confusing, right? It's not it takes a lot of nuance to understand. I still have to, I think I probably still learn every day, and I've been doing this for almost 13 years now. But the unreserved category, if you're filing a new petition post RIA, okay, generally speaking, so you have reserved categories that are still current now. The movement, the retrogression in the latest visa bulletin for the unreserved primarily has to do with a ton of pending pre-RIA filings that are that you probably already have I-526 approvals. It's consular action. We're seeing, interestingly, I guess, probably more efficient consular action abroad. Visas, interviews are going well, and people are getting their green cards abroad. And again, I really don't want to get into the specifics because we don't have a whole lot of time left. But there's a pot of visas every year, and once a certain number are issued, the date goes back because they have to cap, again, because basically there's no new ones left in the current fiscal year for individuals from a certain country. And what you saw with the visa bulletin for April is that the rest of world category may be retrogressed for unreserved, which would be rare. It'd be the first time that would happen. And again, that's investors not from China, not from India, from the rest of the world. And so there's obviously a lot of visas being issued, which is a good thing. We want turnover to happen because that's efficient. We don't want visas to go unused. But if you're a post RA investor, which I assume most of the individuals on this call are, things are still current. Okay, because you're going to be looking at the unreserved, at the reserved categories in terms of your actual filing.
One last question. What about source of funds from India in particular? I would, I mean, they would pretty much similar, right?
Yeah, I mean, I say source of funds from anywhere, right? I've done hundreds of cases from India. There's certain documents that are always going to be readily available from India, right? Whether it's fixed deposits, your provident funds, your bank statements, if you purchased property in the last 10 years, generally those documents are available. You know, India documents specifically become, trickier with ancestral property, cash transactions, potentially sale of businesses that weren't registered. Um, Obviously, whenever documentation goes back a long way, you have to be creative in terms of how you present what happened a long time ago. Normally, declarations from yourself and family members are the best place to start. They're, primary evidence that has to be considered, and you support any declaration with what documents you can obtain. The government wants to know you've done all you can to obtain the best types of documents. So I always say, let's obtain what we can. And if you can't, let's prove to them that you've tried to get something, right? That, the bank statements don't exist from 20 years ago. The property records aren't clear. We went to the registrar's office and it wasn't available. And so that type of, just getting over the hump, right? That extra bit of effort, and explaining what you did goes a long way, and sort of, comforting an adjudicator that may not be entirely clear on a transaction that maybe occurred a while ago. But those are certain things I would say come up more frequently with India source of funds.
Okay. I'm gonna just ask a couple of I have two questions. One relates to the um new administration, Trump administration, and that's opening a Pandora's box. So maybe that's almost not a question for another seminar.
Yeah, you could have a whole webinar on it, but
That one, but this is the last question is a good one. This question is about what kind of docs should one secure if you're getting an unsecured loan from a family or friend?
yeah, so if it's a loan, you want to have a simple loan agreement. They're very easy. That's, very easy to prepare. If it's a close family or friend and you're not going to pay that person back, just you could say it's a gift. That's also okay, and you can have a simple declaration of donation. Again, imagine the money's already yours, right? So if you have the $100,000 and it's yours, the government wants to know where it came from, right? So if a family or friend is going to loan or gift you funds, they specifically will want to know, how did the person raise the funds that they're going to gift or loan to you, right? Do they have savings from a year ago? Did they sell their property? Are they taking a line of credit out, and are they merging that with some other funds? So those conversations are mandatory to have with the person that's going to help, simply because the documentation is straightforward what USCIS requires, but it's mandatory. So every situation is a little unique depending on where the funds are actually coming from.
So you're saying I can't get money from Pablo Escobar?
Yeah, well, you could, but it'd be an uphill battle, that's for sure. And to touch on Trump real quick, I mean, the law is the law right now. That's what adjudicators have to follow. If the law changes, if regulations change, they have to follow different law. They have to adjudicate cases based on existing law and existing policy. You can read, the policy manuals public. You can read it. That's what they use as part of their guide, including the new law and current regulations that are on the books. So. Anyway, that's as of
Yeah,
now, things are what they are.
yeah, yeah. And we don't so far have a gold card, so maybe it's forgotten and we get all.
Yeah, it's not. It's no mention of it in the CR and the continuing resolution as of yesterday. So day at a time, day at a time.
Yeah. All right. Well, Dennis, thank you so much. Always appreciate your time and your guidance on all these matters. Dennis is always available. I'm very thankful for his guidance. We can email him and we get an answer right away. So thank you, Dennis. And we wish you the best to
Thank
you
you.
personally and to your
Yeah,
um
I appreciate it. Thank
and
you. Thank you for having me on. Always nice to talk to everyone, and especially you, Chai. So it's just great to see everyone. Glad we could do this, and always happy to help. Have a nice rest of your afternoon.
And thank you very much for attending our seminar. Give us suggestions on topics you would like to know more about, and we will be happy to put them together for you. Okay. This came out of a sincere desire to keep you guys informed so you can make the right decisions. So let us know what we can help you with. Thank you so much.
Take care, everybody.
Bye.